If you want to be connected with my channel, please press the subscription button and also press the bell icon, and you will be connected with my channel and you will get all the notifications of upcoming videos. If Snowden was an Indian citizen, then what is the law prevailing to protection who unfolding the corruptions in India? So, and whoever fighting against the corruption we can call them whistleblower, and these whistleblower who are fighting against the corruptions are now frequently going to the internet and virtual world and collecting the data which will going to establish the corruption of some top level officers who is eroding or eating into the public money and other thing. So isn't it a hacking? Is it a trespassing in the unlawful trespassing in the virtual world? Is it a crime, or is it an incidents to be booked under 66 IT Act, or a compensation can be obtained by that persons under section 43 of Information Technology Act who is having the dominion and control of that server? And if that happen, what is the safeguard of that persons who is actually fighting against that corruptions? So that is a discussion of that, and that is the topics of today's video. That is, I'm going to discuss about the only law which is protecting the whistleblower in India, and that is the Whistleblower Protection Act. And I'll request you to watch this video till the end. Friends, today we're going to discuss about the Whistleblower Act, the how to expose the corruption lawfully, and if for argument's sake, if any person in India wants to expose the corruption which is deep rooted in the bureaucracy and other thing, and which is a curse to our development, so this corruption can be arrested or addressed or exposed or unfurled by way of the activities of the whistleblower who actually expose or unfurl these corruption and the involvement in corruption by various superior authorities and different persons in the public domain. But now very important question is whether if somebody hack a system and collect the evidence, and somebody works anonymously by whistleblowing the corruption or exposing the corruption, then what is the law in India? Whether Indian law, especially Information Technology Act, will book him under the provisions of section 66 of IT Act, or the ultimate result is will be to providing him with the punishment, or he is immune by the application of Whistleblower Protection Act 2011. So that is our discussion today. If we see is a contraventions, and 66 is a penal offense. So and 66 is an offense. 66 is an offense. And if there would have been no corruption in India, India would have been was one of the most powerful nations in terms of GDP and other, in terms of growth and other. So in section 66 of Information Technology Act, we find that if any person, it is provided that if any person dishonestly or fraudulently does any act referred to in section 43, means if the activity laid down in unauthorized access and downloading the data without permissions from the database and all these been done with fraudulently and dishonestly, then the criminal provisions will apply, and in that case only it will become an offense, and in that case a specific FIR, 66 being a cognizable section, specific FIR will be started. So if any person dishonestly or fraudulently does any act referred to in section 43, he shall be punished with imprisonment for a term which may extend to 3 years, or with fine which may extend to 5 lakh rupees, or with both. Now, given in the situations, if a whistleblower tries to invade into the database or into the online data, or different or access or hacked the data server or database of an organization, in that case whether he will be liable under section 43 for paying damages, or he shall be liable under section 66 for 3 years imprisonment or fine which may extend to 5 lakh rupees, or both. This is our subject today. And 43 and section 66 will no way going to be attracted if the person's whistleblow within the legal periphery of the duties and the provisions within the, he is doing it as per the provisions and following the law laid down in Whistleblower Act, which is the Whistleblower Protection Act 2014. So in India, the whistleblowers, the person who wants to expose corruption, these people are actually protected by way of the Whistleblowers Protection Act 2011. And now going through the Whistleblower Protection Act 2014, we'll see this is an act. In the preamble of this act, it is stated that it is an act to establish a mechanism to receive complaints relating to disclosure of any allegations of corruptions or willful misuse of power or willful misuse of discretion against any public servant, and to inquire or cause an inquiry into such disclosure and to provide adequate safeguards. This is the important thing, and to provide adequate safeguards against victimizations of the persons making such complaint and for matters connected therewith and incidental thereto. So you see, the purpose of the law is very clear: to establish a mechanism to receive complaint relating to the disclosure of any allegations of corruption or willful misuse of power or willful misuse of discretion against any public servant, and to inquire or cause an inquiry into such disclosure. Now there can be disclosure, and those disclosure can be inquired into, and even the person who is disclosing the corruption should be safeguarded, and they should not be made victimized, and they should not be made victimized, and from matter connected thereto are to be discussed in this Whistleblower Protection Act. So if we go by section 4 of the Whistleblower Protection Act, we'll see section 4 provides the requirement of public interest disclosure. So the public interest disclosure is actually the legal requirement. So in subsection 1, we're going to find that notwithstanding anything contained in the provisions of the Official Secrets Act, any public servant or any other persons, including any non-governmental organizations, may make a public interest disclosure before the competent authority. So they can they can make a public interest disclosure. Any disclosure made under this act, so that will be, I think, subsection 2, there is a mistake in that. Any disclosure made under this act shall be treated as public interest disclosure for the purpose of this act and shall be made before the competent authority, and the complaint making the disclosure shall, on behalf of the competent authority, be received by such authority as may be specified by regulation made by the competent authority. Every disclosure, subsection as per subsection 3, every disclosure shall be made in good faith, and the person making the disclosure shall make a personal declaration stating that he reasonably believes that the information disclosed by him and allegations contained therein is substantially true. So in subsection 4, we can find every disclosure shall be made in writing or by electronic mail or so you can see that disclosure can be made by a virtual world. That is the point of today's discussions of this video. So every disclosure shall be made in writing or by electronic mail or electronic mail message in accordance with the procedure as may be prescribed, and contain full particulars and become accompanied by supporting documents or other material if any. The competent authority may, if it deems fit, call for further information or particulars from the persons making the disclosure. No action shall be taken on public interest disclosure by the competent authority if the disclosure does not indicate the identity of the complainant or public servant making public interest disclosure, or the identity of the complainant or public interest is found incorrect or false. So no action shall be taken on a public interest disclosure. That is there. by the competent authority if the disclosure does not indicate the identity of the complainant or the public servant making the public interest disclosure, or the identity of the complainant or public servant is found incorrect or false. So as regards to identity, if it is at all been false, now it comes in my mind or in your mind, I think there is another very important question. If somebody is collecting the evidence and sending and doing this thing lawfully, whether that person is doing it from the dark web or using other anonymous ways, whether that is lawful or not, that is a question of law to be decided maybe after 10 years or after 20 years. But now thing is that if any persons and the identity of the law is very much settled here, the identity of the persons who discloses is to be always kept in conceal, always be concealed. So as per section 8, certain matters exempt from the disclosure. There are some matters, if this is a bar on which a whistleblower cannot work upon. This is the sector areas where certain matters are exempt from disclosure. So nobody can disclose, make any kind of public disclosure with respect to these matters. And the para number 1 says that no person shall be required or be authorized by virtue of provisions contained in this act to furnish any such informations or answer any such questions or produce any document or informations or render any of the assistance in the inquiry under this act if such questions or documents or information is likely to prejudicially affect the interest of the sovereignty and the integrity of India, the security of the state, the friendly relations with the foreign state, public order, decency or morality, or in relation to contempt of court, defamations, or incitement to an offence, and it might involve the disclosure of proceedings of the cabinet of the union government or any other committee or any committee of the cabinet, or as might involve the disclosure of proceedings of the cabinet of the state government or any other committee of that cabinet. And for the purpose of this subsection, a certificate issued by the Secretary to the Government of India or the Secretary to the State Government, as the case may be, or the authority so authorized by the central or state government, certifying that any information, answer, or portions of a document is of the nature specified in clause A or clause B shall be binding and conclusive. And in subsection 2 we find that subject to the provision of subsection 1, no person shall be compelled for the purposes of inquiry under this act to give an evidence or produce any document which he could not be compelled to give or produce in proceedings before a court. So you see that there are in subsection 1 again a very vital matter been discussed, that what are the fields, what are the matters where the whistleblower cannot work, they should not interfere into. So these matters are serious in nature. So whenever, that's why I told you that if somebody expose the corruptions lawfully, and these are the provisions which is actually making the point clear why I use the word lawfully. So as per section 11, it provides the safeguards against victimizations. So when a whistleblower whistleblowing a corruption, in that case the central government shall ensure that no persons or a public servant who has made a disclosure under this act is victimized by initiation of any proceedings or otherwise merely on the ground that such persons or a public servant had made a disclosure or rendered assistance in inquiry under this act. If any person is being victimized or likely to be victimized on the ground that he had filed a complaint or made disclosure or rendered assistance in any inquiry under this act, he may file an application before the competent authority seeking redress in the matter, and such authority shall take such actions as deemed fit and may give suitable directions to the concerned public servant or the public authority, as the case may be, to protect such persons from being victimized or avoid his victimizations, provided that competent authority shall, before giving any such discretions to the public authority or public servant, give an opportunity of hearing to the complainant and the public authority or the public servant, as the case may be. Provided also, there is another proviso clause provided further that in any such hearing, the burden of proof that the alleged actions on the part of the public authority is not victimizations shall lie on the public authority. So you see, there is a huge safeguards provided against victimizations of the whistleblower. And in subsection 3, we're going to find that every directions given under subsection 2 of the competent authority shall be binding upon the public servant or the public authority against whom the allegations of victimization has been proved, notwithstanding anything contained in any other law for the time being in force. The power to give directions under subsection 2 in relation to a public servant shall include the power to direct the restorations of the public servant, making the disclosure to the status quo ante. Any persons who willfully does not comply with the directions of the competent authority under subsection 2 shall be liable to a penalty which may extend up to 30,000 rupees. So you see, even if we go by subsection 4, notwithstanding anything contained in any other law for the time being in force, the power to give directions under subsection 2 in relation to a public servant shall include the power to direct the restoration of the public servant, making the disclosure to the status quo ante. If we go by section 13, the protection of the identity of the complainant, this is another duty provided in Whistleblower Protection Act, and in this case in section 13 says that the competent authority shall, notwithstanding any law for the time being in force, conceal as required under this act the identity of the complainant and the documents or information furnished by him for the purpose of inquiry under this act, unless so decided otherwise by the competent authority itself, or it becomes necessary to reveal or produce the same by virtue of the order of the court. So you see, the identity of the complainant is to be protected, and in that respect, collecting the IP address to identify the whistleblower is not legal, because as per section 30, it is a duty of the competent authority to whatever be in any other law for the time being in force, to conceal the identity of the complainant and the documents or information furnished by him. So this is very important provisions, at least in regards to the any kind of communications made through virtual world, through Gmail, through email and other communications through the virtual world and the electronic world. So in that respect also, the communication, the content of the communication, the identity of the communicator or the complainant are to be kept or protected as provided in section 13. And there are two vital provisions under this act, which I mentioned in one slide, and that is section 16. It says the penalty for revealing identity of a complainant. If any persons who negligently or malafidely reveal the identity of a complainant shall, without prejudice to the other provisions of this act, be punishable with imprisonment for a term which may extend up to 3 years, and also to fine which may extend up to 50,000 rupees. Section 17. Punishment for false or frivolous disclosure. Any persons who makes any disclosure malafidely and knowingly that it was incorrect or false or misleading shall be punishable with imprisonment for a term which may extend up to 2 years, and also we find which extends up to 30,000 rupees. You see, one is the penalty for revealing identity of the complainant. This is a safeguard also given to the whistleblower, and on the contrary, if someone or the whistleblower is publishing or disclosing false or frivolous information, and in that respect also who makes any disclosure malafidely and knowingly that it was incorrect or false or misleading, he or she will also be punished for 2 years imprisonment, or and also to fine which may extend up to 30,000 rupees. So if you go by section 18 of the punishment even to the head of the department in certain cases, where an offence under this act has been committed by any department of government. So say for example, any department of the government is actually identifying the identity or revealing the identity of a whistleblower, or do not follow the other provisions of this law, then the head of the department shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly, unless he proves that the offence was committed without his knowledge, or that he exercised all due diligence to prevent the commissions of such offence. So 2 points which can save you from save his skin, and one is that he has to that it was committed without his knowledge, or that it was committed even after he exercised all due diligence to prevent the commission of such offence. So in subsection 2 we find that notwithstanding anything contained in subsection 1, where an offence under this act has been committed by a department of government and it is proved that the offence has been committed with the consent or connivance of or is attributable, such officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. So you see, there are enough safeguards and provisions which is actually safeguarding the whistleblower from being victimized for their any lawful actions. But I must say one thing: please follow the law. That is, you already discussed about the Whistleblower Protection Act 2011 now, which is 2014, and if any person wants to expose the corruption, he should be doing it lawfully. Lawfully means he should at least have knowledge and follow and comply the Whistleblower Protection Act 2011 or 2014. And if he follows these provisions, then any kind of access into the server or accessing the data and collecting data and disclosing for the benefit of the public is obviously will be, he or she will be immune from any kind of legal provision, legal liability or other. Again, I am telling, unless and until he or she is actually following the law of the land, that is, there is a Whistleblower Protection Act 2014, which is only provide, the purpose of the act is to provide and control the activity of the whistleblower, to provide the safeguard and control the activity of the whistleblower and the other persons who is victimizing the whistleblower. So this is a discussions. I think it's one of the interesting and pertinent in respect of ongoing increase of the corruptions in our society, which we see regularly and frequently. So thank you, friend, for giving me a patient sharing of my today's video. As usual, I'll request you to please share my videos, like my videos. If you require, you can comment any kind of and express your views into my video, and also please subscribe so that you cannot miss so that you may not miss my upcoming videos. So thank you, friends.